Good afternoon, everyone. My name is Trent Taylor. I'm a partner with McGuire Woods, and I'm going to be the one moderating today's food and product labeling litigation and regulatory update webinar that we're having here today. We do these roughly on a quarterly basis. And it's really just intended to be an update on litigation and regulatory developments in the last few months. And we do these to try to keep our clients and friends apprised of what is happening in these spaces. And we're very happy that you were able to join us here today. Before we begin today's program, I wanted to call to your attention a couple things on the platform that you might be able to use today. There's a Q&A icon in the lower left-hand corner of your screen. Please feel free to use this to submit questions you may have for our panelists at any time during the program today, and we will do our best to address your question during the program, and if for some reason we're unable to get to it, then we will follow up with you directly via email. You'll also find a number of other resources along the bottom of your screen which you may explore during the presentation, including the meeting materials folder where you can find a copy of today's presentation slides. So with that, I also wanted to let you know about a couple of other upcoming events that we're putting on. The first one is on June 4 in Los Angeles. It's an in-person live in our Los Angeles office that includes a wine tasting and several panels with industry leaders. If you are in the Los Angeles area on June 4th, we'd love to have you. Also, as you can tell, we love doing webinars, so we're doing another one in June, and this is a slightly different topic, but it's on state consumer protection claims, myths, misconceptions, latest trends, and how best to defend against them. And we welcome anyone on this program who would like to attend that program to sign up for that. Very quickly, a quick advertisement. Here are some of the services we offer in our food and beverage and product labeling teams. A la carte regulatory advice. We do a lot of risk assessments. We put out a monthly newsletter on labeling and regulatory trends called the Labeling and Regulatory Update. And we have clients who subscribe to that, and anyone who is interested should contact us. We also have a labeling and regulatory emergency hotline and dedicated email address for emergency inquiries, both related to food safety as well as labeling issues that crop up. And a lot of our clients do contact us with quick labeling questions that we're able to turn around very quickly. So with that, let me introduce our speakers. We have three panelists in addition to myself today. First of all, we have Jenny Price, who is a partner in our Richmond office. Jenny is an accomplished trial lawyer, and she has handled a broad array of product liability and consumer class actions, and is very familiar with labeling claims, and she'll be talking today about product labeling. We also have Royce DeBuner, who is an associate located in our Chicago office, and he focuses his practice on pharmaceutical, medical device, dietary supplement, food and beverage companies, as well as private equity firms on a range of regulatory matters. Prior to joining McGuire Woods, he worked for an institutional review board and was an associate counsel for regulatory affairs at a company. And he is one of our foremost experts on various regulatory developments, and he will be talking about that today. And last but not least, we have Ben Abel, who's an associate in our Charlottesville office, who concentrates his practice on products and consumer litigation, and has a lot of experience with labeling claims as well as regulatory developments, and I work with Ben frequently on those issues. So very pleased to have our panelists here today. And we also have appearances from some other folks. We have Justin Timberlake, or as I call him, JT. We're going to be having an appearance by Cannabis, as well as Rachel Ray. And I know that's somewhat of a diverse cast of characters for this quarterly update, and you'll see how they fit into what we talk about. So with that, let's get started. I'm going to turn it over to Royce.
Hey, thank you for showing up today, everyone. So the first topic is going to be regulation of cannabinoids. And I say cannabinoids because they are the active ingredient of the cannabis sativa L plant, or colloquially known as marijuana. Just a primer, within the cannabis plant, there's two active compounds. There's THC, which is delta-9 tetrahydrocannabinol, also just known as THC. And then there's CBD, which is a active compound that affects the body's endocannabinoid receptor system, and that does not create a euphoric effect or a high like THC does. So a lot of action in this area. 2018, Congress passed a bill that took basically CBD out of the Controlled Substances Act. Prior to that, CBD and THC were both considered by DEA to be prohibited and akin to marijuana. What Congress did was it kind of redefined the term hemp. And I've highlighted in green some of the main parts here. Hemp is anything from the cannabis sativa L plant, includes extracts and cannabinoids, and it has to be contain a THC concentration of below 0.3 on a dry weight basis. So you can have some THC in there, but it has to be absolutely certain that it's below 0.3, or else you may drift into the world of the Controlled Substances Act and all the penalties associated with that. So, CBD's been a big radar at the state level as well. Georgia, a traditionally conservative state, my home state, actually just made a legal hemp program in the state of Georgia, which means that if their Congress in H.R. 2, the Farm Bill, essentially said, we're going to allow the states to have industrial hemp programs, which means that the state, under the auspices of USDA, can have a program that grows hemp, and from that you can extract cannabinoids. And Georgia and other states have elected to legislate and have those programs in place. So we're probably going to see in states like Georgia and others a growth in the local hemp industry. But a caution there, the Food, Drug, and Cosmetics Act essentially has a large degree of control on what is considered interstate commerce. There's actually a clause in the Act that says that anything that FDA could regulate may be commerce. So a lot of people have said, oh, well, it's intrastate activity, so therefore FDA, can't regulate. And the law is just not clear right now about whether or not you take CBD across the Georgia state lines into a state like Idaho, if that, is permissible. It may or may not be. We'll have to see what the law says there. CBD, though, more importantly, is not grass. It's not generally recognized as safe by FDA. As you all know, every ingredient in food, from Diet Coke to Doritos, has to be generally recognized as safe by FDA. FDA's position is still evolving. They have stated numerous times, including a presentation I was at a couple of weeks ago in DC, that they're going to exercise a wide degree of enforcement discretion on products with CBD, as long as the CBD products do not make disease claims, which is this CBD orange juice can cure cancer. This CBD, cookie can help defeat Alzheimer's. Claims like that are very aggressive, and we have seen FDA enforcement against companies that make those claims. But general claims, health claims, we have not seen so much FDA enforcement on. So some of the advice I've been giving clients is, if you are going to add CBD to your product, just try not to make any sort of therapeutic claims on it. But the states have, in absence of FDA positions on CBD or concerted action by FDA on whether or not CBD is permissible in food, we've seen state and local enforcement of CBD. Oklahoma, this is just an example. There's so many states out there are regulating differently. I just wanted to pull the large sampling of local and state. Oklahoma regulates and licenses edibles. So in Oklahoma, in order to sell CBD in food, you'd have to probably get a state license. Hawaii, just a week or 2 weeks ago, has an evolving position. And most of these are regulated by the departments of health, which are usually the state agencies or the municipal agencies that regulate food safety. And Hawaii's Department of Health says it's currently evaluating its position, but it did give warning letters to everyone selling edibles, basically saying, this is not recognized as safe, and we are going to enforce at any time if we want to, maybe. California still does not allow CBD to be added to food products, but it could be an evolving position. LA County has, and this is an example at the county level, we've seen other counties in the country start thinking more about what they want to do with CBD. LA County is giving retailers till July 1 to get CBD products off the shelf. Idaho has one of the most strict positions on CBD and cannabis of any state. Idaho is just outright prohibiting it. And then New York City has, as was popularly conveyed in the New York Times and other large newspapers, has begun to enforce a CBD food ban. With that said, not every municipality, county, or state is going after CBD. There's still a large amount of enforcement discretion. It is still very gray, and as soon as FDA comes out with a position, there could be a very good argument that there is federal preemption on this space on how to regulate CBD in food. So with CBD, it's a large topic. It could be talked about for hours. I'm going to transition, though, into allulose, which is a new kind of sweetener. We've been monitoring this for a while, and FDA has decided to remove allulose from, if you add it to food, adding the total sugar and added sugar content. So much in the same way as other artificial sweeteners, for a while allulose was not recognized by FDA as falling into that category where it was not metabolized by the human body and therefore did not be declared. When it comes to sugars, FDA's main concern is, one, consumer safety. Is a consumer who is diabetic or on a certain diet going to consume these sugars and have that adversely affect them? This was raised, allulose was raised in a citizen petition, and it's a great example of how you can use the citizen petition process, which is a way for companies or individuals to request FDA to do something, and FDA by law has to respond to it. So FDA was convinced because allulose, the citizen petition showed really good evidence that allulose was not metabolized by the human body and turned into fat. So the reason I mention this is, one, it's a good example of a successful citizen petition. It's a good example of FDA listening to industry and, really looking at the scientific evidence on something. But also, perhaps allulose will be the next Splenda type sweetener. It's really based on how industry wants to use it, but it does have the markings now of something that could be added to food and not cause a caloric gain or, basically convert it into fat. So the next big topic that I've been seeing a lot about is glyphosate. Glyphosate is an herbicide, and it is used widely within the United States. It's been getting a lot of attention because of the Roundup litigation, but I think that one of the things that we have to remember is that although there is this fear of glyphosate out there, I don't know how big it is, EPA and FDA have consistently said that the amount of glyphosate in food is well below the federal limits. So glyphosate's been around since the 1970s. A quick division of labor. EPA regulates pesticides within the United States, so determining whether or not a pesticide is harmful or not harmful kind of falls within the jurisdiction of EPA. But then FDA regulates, additives and harmful substances within the human food supply. So EPA's, in May 6, 2019, EPA was like, okay, well, we're going to, review glyphosate. Our position is still that it's safe and that levels in the human food supply are well below, but we're going to open it up for comments and, hear what the public and industry has to say. I don't think anything's going to change. I think EPA's position is still going to be that the amount of glyphosate in food is well below what is safe. A good example that EPA gave in its Federal Register notice was that, a 10-kilogram child would have to drink 385 liters, so that's a liter is basically a Johnny Walker bottle of orange juice a day to meet the chronic reference dose of 1 milligram per kilo per day. So in order for it to be harmful, you would have to consume an inordinate amount of food or liquids that have glyphosate in it. The levels are just so low, and it's been around since the 1970s. There's a safety profile on it. But with that said, the plaintiff's bar is very active in this area. We have ongoing litigation related to it, and it's going to be a topic in the future that's going to continue to come up. And these are not hard and fast rules on glyphosate. It could change if the EPA or FDA has a different view on it. Right now, I think there's a lot of administrative history of determining that glyphosate in food right now at the levels that it is right now are not harmful, but law evolves, regulatory positions evolve, and what EPA and FDA are doing may be very different than what's happening in the litigation world. Then I turn it over to my colleagues.
Thanks, Royce. Good afternoon, everyone. This is Jenny Price. I'm going to walk through some trends in the product labeling sphere. The first couple slides I'm going to talk about are some recent cases, both that have been filed and some recent decisions in the retail product labeling world. Then I'm going to have one slide on a trend involving what's been labeled safe for pregnancy, which is very appropriate for me right now because I'm about 9 months pregnant. And then I did want to hit on very quickly before I get into those slides a couple of pieces of litigation that have just been exploding across the nation. And the first is the Roundup products liability litigation, which Royce talked about with his last slide. This deals with the cancer risk associated with glyphosate, and there are about 8,000 suits that are going on across the country, which is just a massive number, plus an MDL. I think that there's been a huge rise in litigation over this because there was a $288 million verdict that came out of California State Court last summer. That was eventually reduced to $78.5 million, but still big numbers from one single plaintiff. And that has resulted in just an explosion of cases across the country involving Roundup. So something to be aware of, and we're all watching very closely in the products world. The next one is the National Prescription Opioid litigation. This is interesting because it's not just involving individual plaintiffs, but local governments and attorney generals and state governments have gotten involved in this to try and recover some of the costs that they have at the state and local level regarding opioid addiction. And there are about 1,200 suits that have been filed across the country involving opioid litigation. So that's also something to watch as far as a big trend and seeing a lot of cases filed across the country. Next slide. Thanks, Trent. So getting into some of the more specific product labeling cases involving retail, you'll see a lot of the same similar themes across product labeling that you see with a lot of food cases as well. The first case I'm going to talk about is the Ricola case, which is a proposed nationwide and New York sub class action involving certain throat drops. I'm sure everybody's familiar with the Ricola commercials where they yell out Ricola. But they advertise as being naturally soothing, and the plaintiffs in that case are alleging that, in fact, the throat drops are made from a synthetic material, specifically malic acid and ascorbic acid, and that the consumers were charged a price premium because of the natural aspect of the product, but they were actually deceived into thinking that it was natural and when it contained these synthetic products. So they're seeking not only monetary damages, but injunctive relief to prevent Ricola from representing that the drops are naturally soothing. So products cases are seeing blowback from advertising products as natural, just like we see oftentimes in the food labeling context. Lululemon, which is one of my favorite stores, is facing a lawsuit. It's a single plaintiff lawsuit, Cruz versus Lululemon out of Palm Beach County, Florida. It is not a class action, but what's interesting about this case is that Lululemon had put on the tag on the back of one of its tank tops that it contained 92% Pima cotton. But the plaintiff actually went out and had the tank top tested herself, which again we're seeing a lot in the food labeling world, these plaintiffs going out and getting some individual testing done. And this is obviously in the clothing retail line. And her testing apparently reported that the tank top contained only 36 to 40% Pima cotton. So that'll be an interesting case to watch. Lululemon had originally tried to remove to federal court, but it was just remanded back to state court in Palm Beach County. So we'll take a look at that and see what happens. But testing by individual plaintiffs is not just limited to the food world anymore. The next case is Cabrera versus Bayer, and this is another nationwide class and California subclass alleging Bayer mislabeled its Flintstones multivitamin gummies as complete, but in fact the vitamins were missing K, B1, B2, and B3. Pretty new case, trying to see what's going on with that and if a nationwide class is going to be permitted out in California, which it seems like the California cases are sort of distinguishing mass actions versus class actions and how they're treating Supreme Court cases on personal jurisdiction. So that will be an interesting case to watch to see how that goes forward out in California. The next case is Lube versus Hinkle. This is actually a preliminary settlement for $1.5 million in a class action alleging that the Purex brand detergent had misled consumers. Again, we see this natural element come up in a product labeling case, and Hinkle appears to be trying to settle that for $1.5 million. The next is CVS and others, including Walgreens. They actually defeated a proposed class action. Yay for defendants on that one. And in this case, the product at issue was an aloe vera product that was being advertised as sunburn relief, and the plaintiffs were alleging that aloe vera, in fact, did not provide any sort of relief from sunburn, but then they had no expert testimony to support their claims. And in fact, had some plaintiff's testimony that the product did what it advertised. It relieved their sunburn. So it's always nice to see when a class action gets defeated like that. The next is Aurora versus GNC Holdings. This is a proposed class action involving customers who were allegedly misled into believing that the dietary supplement that they were buying from GNC had been FDA approved because there was no disclosure on the supplements, either on the front or the back, saying that it had not been FDA approved, and they had statements such as it was clinically studied and physician endorsed. And so the claim is that GNC was misleading consumers into thinking that the product had been FDA approved, and it had not been. So that was just filed. We'll be watching that to see how the Northern District of California treats that. Next is another proposed nationwide class action involving maximum strength Robitussin. The allegation here is that Robitussin was advertised by Pfizer as maximum strength, but the maximum strength Robitussin formula had been allegedly changed by Robitussin so that it had less of the active ingredient in Robitussin and more of the inactive ingredients, so that the bottle was still the same size, but even though they were advertising it as maximum strength, it was actually a weaker product, and that's going to be an interesting case to watch as well. New Balance just settled they just got preliminary approval on a class action out in California where they were marketing shoes as made in the USA, but apparently, according to the plaintiffs, parts of the shoe were not completely made in the USA. And that is a preliminary approval of $750,000. There's also a dismissed nationwide class action out of the Eastern District of New York involving flushable wipes. The allegation was that the wipes were being advertised as flushable, but they were actually causing clogs. And the plaintiff in that case that was seeking a nationwide class had actually only experienced one clog. And interestingly, the defendant in this case challenged the class action on a standing basis, and the court agreed and said that a one-time clog was not indicative of a problem that was going to be systemic, and so dismissed the nationwide class on a standing basis. Eddie Bauer is joining other retailers like Kate Spade, Barney's, and Ralph Lauren in being accused of deceit at its outlet stores by, I'm sure everybody that's been to an outlet store knows, you look at the price tag on specific items and it'll say something like original price $70, and then underneath it it'll say, what the discount price is for the outlet price, $45. And essentially what they're saying in this lawsuit is that Eddie Bauer never actually offered whatever item is at the outlet store, let's call it a pair of pants, for $70, because it's a different product at the outlet store than what they sell in their regular stores. And so it's deceptive to consumers that are paying $45 at the outlet store thinking they're getting a great deal because the price was originally $70, but in fact those pants were never ever offered at $70. So it'll be interesting to see how the court treats that out in California. And finally, for our retail case wrap-up, we have a potential class action that was not certified at the trial court level out in California. It was a state court case involving Rite Aid that was purportedly falsely advertising the size of kiddie pools. The kiddie pool apparently fit like 3 adults and 2 children, but on the packaging of the kiddie pool, there were, 4 adults and 4 children or something like that. And consumers were saying that they were buying it based off of the photograph, and
it's almost like a slack-bill suit.
Right, exactly, Trent. But then they'd get the kiddie pool inflated and put water in it, and they weren't fitting as many people as the photo. And the trial court had denied class cert because the plaintiffs could not present evidence about how to identify the members of the class. But the California Supreme Court, at least based off of oral argument that occurred earlier this month or late last month, there hasn't been a decision that's been rendered, seemed to think that identity of class members was something that should be addressed at the notice level and not necessarily at the class certification level, which I thought was incredibly generous way to be reading class law. But we'll keep our eyes on that as well. The next slide, we are going to be talking about a trend that is making its way through advertising for potential retailers and distributors, and is something to keep an eye on with litigation, and that's an increased awareness of how products and chemicals and other items you should avoid while pregnant, because it may lead to harmful effects to the fetus or to the pregnant woman, and that there are more retailers and distributors that are, instead of saying, like you typically see with like an alcoholic beverage or a tobacco product where it clearly says, for pregnant women to avoid consumption of those, it's the opposite of that, where manufacturers and retailers and distributors are actually marking products as safe for pregnant women. But there hasn't been a ton of research into areas of, cosmetics and face washes, body washes, et cetera, that are in fact safe products for women that are pregnant. And, this is a big trend in what you're seeing in a lot of typically women's magazines, such as Vogue, Harper's Bazaar, Self, and The Bump, are actually instructing pregnant women products to avoid. I know, just on a personal note, when I was looking for a new face wash when I found out I was pregnant, there are specific face washes that are marketed towards pregnant women. The one I have sitting on my cabinet right now is like a maternal face wash or something like that. So there are a great deal of products out there that are holding themselves out as being safe for pregnant women, but they really haven't been tested, and there's not been a whole lot of research to establish the safe levels of chemicals and whatnot. So the FDA is facing increasing pressure to update the Food, Drug, and Cosmetic Act, which hasn't been substantively changed since 1938, which I think is just absolutely remarkable. So you're seeing this not just with products that are being advertised for pregnancy, but cosmetics in general. There's a big push to update the Food, Drug, and Cosmetic Act. So again, sort of like what I touched on at the beginning of my presentation about this rise in natural, non-toxic, and clean beauty product potential litigation, just like we've seen in the food industry and just like we've seen in product labeling with some of the cases that I just discussed. And a good example of this is, I don't know if everybody's heard of The Honest Company. It's actually owned by Jessica Alba, who's an actress, and she started The Honest Company, I think, right after she had her first child. And the premise of The Honest Company is to have natural and organic products for not just babies, but also for pregnant women. And they have faced several class actions in the last several years, accusing the company of marketing 41 of its products, such as sunscreen, shampoo, body wash, as all natural or 100% natural, even though they contain unnatural or synthetic materials. And I know that they've settled at least 2 of those lawsuits. for under $10 million, but for multiple millions of dollars. So, thanks so much.
Yep, thanks, Jenny. We're going to turn it over to Ben now.
Hey everyone, this is Ben Abel. I'm an associate in our Charlottesville office, and I'm going to talk a little bit about some recent trends that we've seen when it comes to food labeling litigation. And before I get started, I wanted to focus on some interesting and emerging areas in the law, and didn't want to devote our time to the half a dozen cases that Trent is going to probably talk about towards the end, but B, the acid suits, malic, ascorbic, citric acid, typically presented as a no preservative or artificial flavoring suit, remain probably the biggest thing going these days. We continue to see all natural suits, despite the fact that the FDA has continued to leave us high and dry on what the heck natural means. We thought that we had probably thought that we had buried slackfill litigation. Trent will talk a little bit that slackfill seems like it might be back, at least more than we expected. So kind of the big things that were going on previously, the bigger trends that Trent will touch on, continue to exist. But I just wanted to focus on some more smaller areas that we and provide some advice that we thought might be helpful. The other thing I'll mention is that ingredient suits remain really big. In part, there's a couple of plaintiff shops out there that seem to pick an area or ingredient by month and send out suits or file suits on a couple different products every single month. So last month was cocoa month. There were a couple of suits that were filed alleging that products that state they include real cocoa, the allegation being that they include cocoa with alkaline, and therefore the labeling was allegedly improper. Graham flour and graham crackers a few months ago, it was graham cracker month. And so we're continuing to see ingredient suits. But the first one I wanted to kind of spend some time on are increases in healthy halo litigation, in halo litigation generally. Again, healthy halo being a more esoteric idea of what a labeling lawsuit would look like, which basically says that your overall labeling and advertising and marketing gave a consumer an impression that this was somehow a healthy product, and not necessarily focusing on a no sugar added claim or a no preservative claim, but just a general feel that we got. And so the first three cases here on the slide, Testone, Grouse, and Adrade, Hemsfield, we have seen for the past couple months, one a month, I believe, suits that have been filed alleging that coconut milk is advertised as being healthy, as including healthy fats, quote unquote, and the allegation is that these are in fact not healthy, that there basically is no such thing as a healthy fat, and that these contain dangerous levels of saturated fats, dangerous levels of added sugar, leading to all of these increased health risks. And part of the allegation is essentially, like we said, a healthy halo claim, that you made your product seem like it was healthy and good for consumers when in fact they've got all the saturated fat in them. These complaints are incredibly long, at 40, 50, 60 pages long. They've got a lot of research in them, but they are, and again, I said we're seeing about one a month, so these healthy halo claims are kind of the next big thing here. The next one, the Warner Starkist case. This is a case alleging that Starkist had a heart check mark on its labels, saying that it was heart healthy, essentially. And plaintiff sued and alleged that it was not properly disclosed that the heart check mark, at least according to plaintiff, was a paid endorsement, and as a result, that consumers might not believe the heart check mark. That case partially survived a motion to dismiss on what a reasonable consumer would or would not believe about that heart check mark. And so again, another mark that's intended to make a consumer believe that the product is healthy. That litigation has continued. And then the last one here is less of a healthy halo claim. Basically, the claim is alleging that the labeling on A&W root beers and cream sodas, which, as you might recall in your mind's eye, kind of includes barrel imagery. The allegation is that the labeling gave the false impression that the products were made with the same ingredients that would have been used at the time that we still barreled our sodas in this country. And specifically, the allegation is that it's not made with real vanilla, which the plaintiff alleged would have made it a creamier soda without increasing the calories and fat in the product. And I think that case is interesting because it demonstrates that it's not necessarily just healthy halo cases that we're dealing with, but nostalgia halo, old-timey halo. Increasingly, everything or a lot of things seem to be halo cases these days. So when you in-house are looking at a label, whereas before you might have looked at each specific claim made on the label and then tried to reference the CFR or some other guidance to determine, okay, is this specific claim okay? Does this specific claim comply with the Federal Register, or excuse me, the code? And now, label review, part of that should probably include taking a step back and say, does our label give a general feel that the product is healthy or made with an old-timey processing method, or any of these kind of other halo-type claims? And if so, what label might that expose us to? And so taking a more holistic look, and that's kind of a squishy concept, I understand, but when we look at labels that come from clients, that's one thing that we consider now is, what halo does this label potentially give off? The next thing I wanted to talk about is country, region, state of origin litigation. And just last month, in the Kona beer suits, this is a suit alleging that Kona beer gave the impression that the beer was actually brewed in Hawaii when Kona actually had a tap house in Hawaii, but all of the beer bottled in the United States was actually brewed and bottled in the mainland. And in an SEC filing, which is kind of an interesting place to find information about a potential settlement, Kona Beer's owner, the Craft Beer Alliance, said that they were preparing or were anticipating settling that claim for $4.7 million. And there's some other specifics as well. But other than that being a big number, it can show that if and this is a case that had gotten past a motion to dismiss, had been certified as a class, and the Ninth Circuit had then told them you can't appeal the class certification, these country, region, state of origin claims can be expensive for manufacturers. The next one on the list here is a suit that's been filed that alleges that products, that tomatoes that were labeled as San Marzano tomatoes weren't actually grown in the region and were grown elsewhere. And then the allegation obviously being that plaintiffs allegedly pay a price premium for these very special tomatoes grown in a very special part of Italy. And part of this allegation was that the labeling did not include the requisite or what other competitors were doing, which is the specific information about where the tomatoes were grown. So, to the extent that you have on your label a region claim or a state claim where the product is made or manufactured, that is getting increased focus from plaintiffs. Similarly, the next case, the Pinnacle Foods case, deals with an allegation that Hawaiian kettle-style chips were not actually made in Hawaii, and despite the Hawaiian kettle-style chips, Hawaii apparently has a statute about the Made in Hawaii statute, and so part of the allegation here is that this was violative of the Made in Hawaii statute. And so again, if you have a style product, there is potential, at least for litigation, that if your style product is not made wherever the style is from, that a plaintiff may object to that, even if you think you actually are making it in whatever style it is. And then the last two, kind of like the San Marzano tomatoes case, are two different cases, one brought by a consumer and one brought by coffee growers in Hawaii, alleging that Kona coffee sold by a host of coffee sellers in the United States wasn't actually from the Kona region of Hawaii. And again, this is a suit, and these complaints had a lot of laboratory analysis of the coffee grounds, that they don't have the characteristics of Kona coffee. So again, these country, region, and state of origin cases are heating up, we think, and to the extent that you're making such a claim, it's important to think about what potential liability may or may not be associated with that. I wanted to talk for a moment about retail. There were a number of retail or restaurant GCs that were signed up, and this is kind of the forgotten area of food labeling, an industry typically dominated by packaged foods. But we are seeing more and more retail suits be filed, and if you can think of a way that a packaged food suit could be brought in retail, it's out there. So the first is an allegation that Panera, the blueberries in its bagels were not actually blueberries, and this is something that we saw with Dunkin' Donuts also faced a similar suit. Panera also is facing a suit that its food is not clean, because it allegedly contains glyphosate and other herbicides and fungicides that Royce and Ginny both talked about. One that's interesting is this Bear Burger suit, alleging that the products were alleged to be or advertised as being organic, but while the burgers may have been organic, plaintiff is saying that, well, the tomatoes, for instance, weren't actually organic, and that wasn't disclaimed on the menu. So, thinking long and hard about the menu, and is every ingredient compliant with the advertising that we're making, which leads us into, and this is, I think matters for everyone, not just food labeling. Websites and social media matter. Sanderson Farms is a good example of this, where they are continuing to fight a lawsuit over not the labeling on the product itself, but the advertising and other marketing, including online marketing, that gave the impression that the products were natural. And the court has held that a consumer not make a close reading of all of the website and all of the advertisements to sustain their suit. So lest you think, all of this stuff is disclosed somewhere on our website, that might not be good enough, especially at the motion to dismiss stage. And finally, these last two suits involve social media and plaintiffs who have alleged that in part they relied on social media advertising to purchase the product. And I think it's important for manufacturers, if you think that advertising and marketing and the social media team that you may have, if they are separate and apart from what the advertising and regulatory side of things are doing, if those two hands don't know what the other are doing, there's a potential for some liability or potential liability going forward. So with that, happy to answer any questions that people may have in the chat window, but I'll turn it over to Trent.
Thank you, Ben, and thanks also to Royce and Jenny, and I especially wanted to thank Jenny for being a trooper doing this while on the cusp of giving birth. So thank you, Jenny.
Sure.
What I want to focus on for the last 10 minutes or so of our webinar are trends. I'm always very interested to look at overall trends, the forest rather than the trees, the 30,000-foot view. And I want to start with Chief Flavor Officer Justin Timberlake. Now, you may think I'm trying to be funny here, and I am trying a little bit, but this is actually a real case. He was recently sued, along with Bay Brands, for misleading consumers with the ingredients in their drinks. And in the complaint, he was identified as not as one of, but the Chief Flavor Officer for Bay, in part because he supposedly invented a new kind of fruit. He apparently appeared in a commercial for Bay where he mused about his new fruit concoction, a blueberry stuffed inside a raspberry, which he named a brassberry. You really can't make this stuff up. You see what they look like there, and apparently one of the fruit companies is now selling brassberries, separate and apart from Bay Brands. So, in any event, obviously Justin Timberlake is a multi-talented man. Here is the actual case, and the suit targeted primarily the presence of malic acid in Bay drinks and the label claim of all natural. Now, the court dismissed Justin, finding that he's not subject to jurisdiction because he's not a California resident. So that obviously is fantastic because it frees up time so that Justin JT can create even more new fruits and maybe even put out a new album. But all joking aside, this is a helpful decision because it pushes back on the plethora of malic acid cases. We've had a lot of malic acid cases that have been filed, particularly in the Southern District of California. And this is helpful because it rejected a claim that malic acid needed to be listed in the ingredients as DL or synthetic malic acid. So that's helpful in that regard. One of the things that Jenny talked about earlier, and Ben as well, lab tests. Lab tests are really, really important. Plaintiffs' attorneys are pulling products from shelves and having them tested at labs. Does it contain what the product claims it contains? And as Jenny mentioned with Lululemon, it's not just for food. It's for clothing and personal care products. It's really for everything. And these are they're a different type of case than your typical food labeling case because they're a lot harder to get dismissed at the motion to dismiss level. Let me give an example of why. Here's a case from a week ago. This decision came out 1 week ago in the Northern District of California, and it denied in part a motion to dismiss, finding that even though the plaintiff didn't allege the details of the lab results upon which she relied, that they still could get past the motion to dismiss stage. And one of the things that, being involved in these cases before, one of the things we try to do is we try to attack from an Iqbal Twombly standpoint whether or not there's sufficient details of the lab testing. And the reason why it matters is because I've been in multiple cases where you have a plaintiff saying, I rely on lab results, and then you get to the end of the case and you find out that they had a completely different methodology than what is appropriate, and they weren't even testing for the right stuff. But it can be very expensive because you get to the end of the case before you find that out in some circumstances. We've already talked a lot about glyphosate, so I'm not going to talk any more about it other than to flag this particular decision from about a month ago, which dismissed a suit targeting a dog food company that contained glyphosate. And this is a welcome decision because it says that trace amounts of glyphosate by themselves are not an issue. You need to allege how it was harmful. And this obviously is very different than the Roundup cases. I know many folks probably saw the Roundup verdict from, I think, 2 or 3 days ago that was, I think it was $2 billion. But obviously that's very different because it was long-term exposure and a lot more exposure than what you're seeing in some of these food cases. Front versus back labeling. So we're seeing more and more suits ignoring the back label altogether, arguing that consumers don't look at the back label and that it doesn't matter what a manufacturer puts on the back label. All that matters is what is on the front label and the impression that is given. And here is one case where that occurred. It denied a motion to dismiss, and the complaint quoted the survey finding that 90% of consumers buy items after looking at only the front of the package. So it's no longer the case that putting something on the back label is going to protect you. And this is true even if you don't have something on the front label that is misleading. We're seeing omission cases alleging that something on the back should have been on the front label. So we're seeing more and more of those types of cases. Ben's already talked about sponsored endorsements, so I will skip over that. But this is a pretty big development. And we've also seen a lot of FTC actions on this as well. So if you have anything that can be construed as a sponsored or paid endorsement, that needs to be disclosed, or else you are opening yourselves up to potential liability, either from plaintiff suits or FTC actions.
Trent, we've also seen suits where basically plaintiffs have alleged that a manufacturer made up their own symbols and put them on the label, and plaintiffs have alleged that that is deceptive. So even if it's not a paid endorsement, if you're making it up on your own, that might be an issue.
Yeah, that's a really good point. I believe there was one where there was a claim that someone had a company had a mark that looked like a non-GMO project certification. It looked a lot like it, even though it wasn't. It was something that they had developed for their own. So that's a really good point. I know we're running out of time, so I'll move quickly through the rest of these. And like I said, this is just to give you a high-level view of some of the trends. We're seeing a lot more suits filed in New York. That's a trend that we've identified in past updates that we've done, but it's really sort of staggering because every time I see a new development in the last few months, I look at the case and it's almost always from New York, either Eastern District or Southern District. So be aware of that. And competitor litigation, Lanham Act claims. We're seeing a lot of those. And here are a couple of examples. There are lots of others that I will not get into here. But it's always good to keep in mind that the threat doesn't come just from the FDA or USDA or from the plaintiff's bar. And this is a tactic we're seeing more and more companies do, and it can be very, very effective. And it can also lead to the plaintiff's bar getting involved. And we've seen that happen where a competitor sues another competitor, and then the plaintiff's bar sees that and says, you know what, that's a great idea. I'm going to sue as well. So be aware of that out there. Diet soda, we've seen several of these suits, and it appears pretty much to be on life support now after this Second Circuit decision a couple of months ago that affirmed the dismissal of the suit. There is a Ninth Circuit case still pending, and we'll be watching that to see what happens. But if that goes the way, affirms the dismissal for the defendants there, then that will probably be the last we see of diet soda suits. More on coconut products. This is something that Ben identified a little bit ago, and we're seeing a lot of these targeting coconut milk, coconut water, and products that have coconut in it. And so if you have a product that has coconut in it, then you need to really be aware and pay very close attention to these suits because there's a lot of them and they're becoming more frequent. And one defendant in one of these suits called it a war on coconut products. I'm going to skip over this one because this dovetails into what Ben was talking about earlier, as well as with lab testing. There's a lot of not enough and not actually claims. Not enough keratin or not actually keratin in the product. So that's a really hot topic. And you see all of these cases that I have on here are from New York, federal courts in New York. Slackville, we thought it was dead. I think we're now seeing that it may not be completely dead. There was a class certification just a couple months ago in a California case. So, and we've seen at least one or two other new black bill cases filed. So we'll be keeping an eye on that to see if there's an uptick after that grant of class certification. Natural, we've talked about this before, but we had a recent decision where yet another court said, I'm no longer waiting on the FDA to come out with a uniform natural standard. There's no indication that they're earnestly working on it, and we can't sit idly by waiting on them, so we're going forward. And I think just about all of the cases that had been delayed, waiting on the FDA, are now active again. Product labeling, we've already talked about this. That's what Janine was talking about. Here's a case that was filed 2 days ago claiming that certain amino products that claim to relieve stress don't actually do so. And I don't know how anyone could claim that lavender doesn't provide stress relief. It's providing stress relief for me just looking at the photo of lavender. But all joking aside, product labeling is a really, really hot area. And what we've seen in the food and beverage industry and all the labeling claims, we're now seeing that in the product labeling space. One other thing real quick, and then I'm going to wrap up. Some people might have seen some of the recent articles about sunscreens and how they're absorbed in the skin. One of the things that has not occurred yet, but one of the things we try to do is we try to see what's going to be next. Not even here yet, but what's next. And I think there's a decent chance we could see lawsuits focusing on sunscreens and one of the active ingredients, which is oxybenzone. And oxybenzone is not just in sunscreens. It's in hairsprays, it's in cosmetics, it's in nail polish, it's in food packaging. So oxybenzone could be the new glyphosate. So I just want to flag that for everyone to be aware of. And then at the end of this, I have some class decisions, including one that was issued just yesterday. And they're class cert decisions. I think they're helpful. They're mostly on damages, or two of them are on damages, including the Kurtz case from the Second Circuit. It's a very helpful decision on damages and whether you can show harm through common evidence. So I encourage y'all to look at those cases on your own time. And then finally, the last slide is on DOJ intervention in class settlements. DOJ is very active right now. They're filing objections to class settlements all over the country. And they're trying to make a splash, and they want to make sure there's value for the class and not just for plaintiffs' counsel. And a lot of AGs are doing the same thing. So that's something that you need to be aware of. And before you enter into a settlement, you need to look at those objections and make sure that that's not going to happen to you. So with that, I want to thank everyone for appearing on today's webinar. Thank you so much, and we'll do more of these later. And if you have questions or wish to contact us about anything, feel free to do so. You can get our emails from the website. Thank you.